we heard on the one hand, Vice President Biden as the candidate saying, look, I've been accused of sexual harassment by this former staffer of his, but I'm entitled to my fair day. I want the media to investigate and vindicate me. And on the other hand, now President Biden has started to criticize some of the things that we were doing. And it makes you think, am I taking crazy pills? Do I hear the same person talking about...
Welcome to politics.
Right.
What could be more sympathetic than a couple of old guys talking about sexual harassment? Because apparently we know. Will Trachman, thank you for being with us.
Absolutely. Thanks for having me, John.
You worked with Betsy DeVos in the Trump administration, the Department of Education, to undo some really terrible regulations when it comes to students who are charged with sexual misconduct. I wanted to say what your position was, but it was so very bureaucratic, there is no way I can do it.
That's right. So as I was living in D.C., as a swamp creature, I had one of these typically bureaucratic titles. So I was Deputy Assistant Secretary for Policy and Development in the Office for Civil Rights at the U.S. Department of Education. I called myself the DAS pad sometimes just because the title was too long.
I wonder how you filled that out on your taxes. It says occupation. Anyway, there was such an issue in the Obama administration when Obama put together a letter of direction, would that be the best way to put it, to colleges and universities of how they are to handle accusations of sexual misconduct. And it wasn't really a regulation, but it kind of was. What was it?
Yeah, so it's funny that you talk about that because it's not a regulation, it's not a law. You know, we grow up learning about the three branches of government, the executive, judicial, and legislative. And one thing that a lot of people don't know is that under the executive branch, there are a bunch of agencies that make their own laws. So one of those agencies is the Department of Education, and they issue regulations. But even those regulations are a little bit hard to do sometimes. They take time. You have to open them up for notice and comment to the public. So if you want to just get around all that, you issue what's called a Dear Colleague letter. And that is just a letter that it gets posted on the website. It's addressed to every school, colleges and K-12 schools, saying, look, if you don't want to lose your federal funds, and we define federal funds to include scholarships, Pell Grants, everything, you better pay attention to what we're saying.
All right, this is, I heard how outrageous President Trump was that, he ran amok over the Constitution and he did all these things that a president should. And I'm thinking, wait a second, I remember Obama saying, I'm going to use my pen and my phone if Congress won't get in line. And this is one of his pens. He did not go through the rule-making process, which is, there's a lot of bureaucracy that happens there, a lot of due process, a lot of hearings, a lot of public comment, and it works at the speed of government. He just wrote this threatening letter to every college and university that said, if you don't do the following, we're going to cut your funding. And because you're higher education and you're risk averse, they stepped in line.
Oh, yeah. No, if you are a school and you're deciding, should I go ahead and disobey the Department of Education, or should I go ahead and step in line and make sure that my federal funding is secure? There's no question. There is no lawyer for any school that will say, take your chances with the Department of Education. You'll probably be fine. So, yeah, you're absolutely right. The amount of time it takes to post a Dear Colleague letter is the amount of time it takes your staff to access the website and put the link up, because there is no notice, there's no comment. It just happens. And that is a way of short-circuiting the process.
It really is presidential fiat. No matter who does it, it's a terrible process. All right, so what did this letter say, this Dear Colleague letter, tell colleges and universities?
Sure. So this process has actually been given a derisive name, the rule by letter process. So it started under President Clinton, under President Obama in 2011 and 2014. They issued more letters, continuing to update.
Are you telling me that George W. and Donald Trump didn't do the same?
Well, not on this issue, at least. So on Title IX, this is the statute that prohibits schools from discriminating on the basis of sex, and which has been interpreted to cover sexual harassment. The Bush years were relatively quiet years in terms of guidance letters on this topic. And really, between 2001 and 2011, not a lot happened to change. So in 2011 and 2014, the Obama-Biden administration issued these letters saying, you need to really be careful about letting accused students have a right of cross-examination. If they're accused of sexual harassment, it could re-traumatize the victim. You got to be careful about what evidence you give them because the accuser has privacy rights. And so just limit the amount of process that you do before you expel a student, suspend a student, notate their transcript, make it clear to the public that they've been charged and convicted with sexual harassment in a kangaroo court. And we arrived in 2017 against that backdrop with very little hesitation.
Well, let me play this out for a second. I get the reasoning behind this, that as a father who's going to have a daughter going off to college, I want to make sure she's safe. And if there's somebody that abuses her, I don't want her to have to face him in class. I will want that guy out.
Of course.
And due process be damned. This is a place where we expect safety for our students and our kids, particularly girls. So why not do away with that due process just to be certain?
Well, due process is part of the fundamental rights of our country, and a lot of the time these are public schools that are engaged in these accusation processes and trials that are happening. But even when it's private schools, they've made an agreement with the government to accept federal funds. And part of the statute and the regulations is that your processes have to be fair. You can't expel students on a whim. And so even in these very traumatic situations where a credible accusation of sexual harassment is made, you still have to give process to the accused student. And that process benefits both sides in the end. You know, if it's just simply the case that all accused...
Do you have any examples of where it went wrong because there was such a rush to judgment that was proven to be wrong?
Well, in the criminal court, these cases...
I'm talking in college cap.
I know you mean. So in the criminal court, it's beyond a reasonable doubt standard.
Right.
In these cases, the Obama guidance mandated that it was a mere preponderance standard. So, of course, if there's any chance...
Put that into English for me.
Yeah.
I know you lawyers like that kind of crap. So reasonable doubt versus preponderance of evidence. I hear mumbo jumbo both ways.
Sure.
Make it simple for me.
Yeah, so in lawyer language, that is just like plain English, but thank you for reminding me that I'm a lawyer. I have to live with that every day when I look in the mirror.
I can only imagine your mother's shame.
So anytime you hear about a criminal case going to court, the defense attorney says, look, this has to be proved beyond a reasonable doubt. And that's a very high standard. So if jurors are going to convict and take away someone's liberty, they have to be very certain about it. That's exceedingly different from what happens on campus. And the Obama administration said, not only can you not use the beyond a reasonable doubt standard, you can't use any standard above 50% plus one. That is the standard. And so that's what colleges adopted and K-12 schools adopted. And so anytime you have a 51% standard, you're going to have cases where guilt occurs and
so,
ought not to.
Under the Obama rules, when you say it doesn't allow for cross-examination, let me see if I've got this right. The accused, can stand up in front of the administrators and they can pebble, a bunch of questions. It's not a court of law.
Right.
Not a court of law. But whoever's defending or that accused person can't then go to the accuser and say, wait a second, what about this, and this? That doesn't happen. So the idea of that great American tradition of facing your accuser doesn't exist.
That's right. And so last year, as we were trying to correct this in the Trump administration, we heard on the one hand, Vice President Biden as the candidate saying, look, I've been accused of sexual harassment by this former staffer of his, but I'm entitled to my fair day. I want the media to investigate and vindicate me. And on the other hand, now President Biden has started to criticize some of the things that we were doing. And it makes you think, am I taking crazy pills? Do I hear the same person talking about...
Welcome to politics.
Right.
All right, so First of all, tell me a little bit about Betsy DeVos before we talk about what happened. I just think this woman is aces. I think she has always been somebody who wants to see people get a better education and have some level of choice in it. And so for Department of Education head, not only was she a dignified and person, but really, really impactful and effective. Am I seeing that wrong at all?
No, not at all.
I know that's a softball and it shouldn't be, but I've met her, I've talked to her, and I just really feel that she was one of the great picks that Trump had.
Absolutely. So I try not to be too much of a DeVos groupie. You don't want to brown nose after you're out of the department. But she was terrific. She was smart in a way that she didn't get credit for. She was an effective leader. She absolutely commanded, as a good leader ought to, the direction of the agency, and in some cases gave ideas to the lawyers as to how to manage cases, how to ensure that either due process was appropriate or maybe the burdens on schools across the country were appropriate. So she was absolutely everything that you would want in a Secretary of Education.
Why did she take this on? Because here she is, a woman in the Me Too era, with a special deference to women who accuse versus those who are the accusers rather than the accused. This is a hot wire. It would have been really easy to just let this one go. Nobody would have known it. Instead, she took a lot of heat for this. You must have gotten an earful of it. Why did this raise to the level of being important enough that you had to undo it?
Yeah. Well, so obviously she's very principled. She wasn't going to duck a major fight just for the sake of convenience. But
she's obviously not a politician.
That's a fair point. But the writing was on the wall when the administrations changed from Obama to Trump, that this was going to have to be something that was addressed. Courts had started striking down college campus findings, saying that a public school had failed to satisfy a due process. And so this was something that needed to be addressed. So in September of 2017, Secretary DeVos gave a major speech saying, this is something that we're going to tackle. It took us all the way from September of 2017 to May of 2020 to actually get it done. So this was no short investment that we just hoped, this will take up a minor part.
If people don't understand how, I don't want to use the word evil, how dangerous government is. So all it took was for an Obama employee to write a letter saying, dear colleagues, do this, this, and this, and this. This is what we think. And remember, we fund you. Put it on a website. That was all the due process it took. It wasn't even a regulation. Right. But in order to undo it, it took 2.5 years to just go to the webpage and hit delete and unpublish it.
Well, we wanted to promulgate our own good policies. So we wanted to say, okay, you have a right to cross-examination. And we wanted to codify it into law. This is the first time ever that anyone has bothered to enshrine protections against sexual harassment under Title IX into federal regulations. Clinton didn't do it. Obama didn't do it. These are just letters. They're not regulations. So Secretary DeVos is responsible for enshrining these protections for the first time ever.
Well, that is not what I heard on television or read in the papers.
Oh, you don't say.
No. So let me see if I'm understanding you right. What I heard is she took that paper that, this is crap. We'll just get rid of that. All right, that's what I heard happened. That's not what happened. She actually went through the slow slog of regulatory change to put something into Title IX that talks about this issue.
That's absolutely right, yes.
And what does it do?
So in a number of ways, it creates the framework for how a school has to respond to an accusation of sexual harassment. So if a student says, look, I was sexually harassed, a school has to respond to that in very specific ways at the outset, and then they have to investigate the accusation and provide both sides with due process to determine whether the accusation is true or not. And then they have to remedy the situation. Oftentimes that'll involve disciplining a student if they were responsible, and if not, then they go forward.
Why not just leave it to the courts?
Well,
if somebody is attacked, if somebody is wronged, we have laws and we have police and we have judges. If something happens in the grocery store, it's not like Safeway is there to put together a court and make a ruling. You call the police; they take care of the situation if there was a violation.
Yeah, it's a good point. There is some disconnect there between if you have a violent crime that occurs on a college campus, and of course the police are involved and there's a criminal process. It seems a little bit weird to say, well, also we're going to decide whether to suspend you or expel you. But that's just the way that the federal statute works. So Title IX covers sex discrimination, which courts have decided means sexual harassment. And of course, the agency, the Department of Education, has a duty to enforce Title IX. So this is just one part of a larger constellation of
another thing that whatever happens here runs all the way up to D.C. for guys in fluorescent lit office buildings to decide our lives. All right, congratulations on getting that done. I mean, it is important that there be protections, but also that there be real due process and a presumption of innocence, and all those things we were taught was important. There's a different president.
Yes.
You no longer have that title. And by the way, as quickly as you can, that title again was?
Deputy Assistant Secretary for Policy and Development in the Office for Civil Rights at the U.S. Department of Education.
So now that you're working for a real job, you say a lot of, would you like fries with that? So actually, you're working now with a great organization, Mountain States Legal, friends of theirs for a long time. What a terrific thing to have. But you're not working for Trump anymore because there's been a change of the guard. So what does that mean for this issue that you've invested so much in?
Thank you for that question. Yeah, I walked out at 11:50 a.m. on January 20th, hoping that the work that I had done over the previous 3 years would survive in some way. Since leaving, I've been honored to be Associate General Counsel at Mountain States Legal Foundation, a terrific public interest firm here. We do a lot of property rights litigation, equal protection litigation, and Second Amendment litigation.
Including representing me in my home city of Boulder.
That's right, exactly. Now, we have seen already the moves by President Biden to undo a lot of the work, despite his own personal situation, which I just referenced, involving an accusation of sexual harassment. So the new folks in the seats in my old agency have issued letters saying we are going to reevaluate these regulations, and an executive order that the president issued fairly recently said, I want the department to consider modifying, re-regulating, or maybe suspending these federal regulations.
Wow.
Which is new to me. I had not heard that you could just suspend a federal regulation until this executive order.
You have to go through the process.
Right, exactly.
So let me see. They want to avoid the process so that people who are accused on college campuses also avoid their due process.
Yes.
I'm noticing a theme.
That's right. So just recently, the acting Assistant Secretary for Civil Rights, so the person who used to be my old boss, basically, announced, we're going to start this process. We're going to reevaluate the regulations. We want to hear public comment on how important it is to change this process. Now, the benefit of what we did is that it ought to be very hard, right? It took us a long time because we weren't just issuing the letters. So if they want to undo this, they're going to have to commit a significant amount of resources and time, I would think, unless they really do plan on short-circuiting somehow that I haven't heard of, they're going to have to make this a priority.
Another lesson of why elections have consequences. Well, thanks for doing all that. Welcome back to Colorado. I'm glad you're with Mountain States. I'm sure we're going to be seeing a lot more of you.
Thanks, John.
If you enjoyed that conversation, by all means, click one of these other great programs. We have the best conversations with the most fascinating Coloradans. And subscribe to our channel. Just click down below and hit that little bell button too. You don't want to miss a single show.